Hello, my name is Professor Angela Daly and I work here at the Chinese University of Hong Kong Faculty of Law. In this short video on internet law, I am going to talk about digital intellectual property matters. I will give an introduction to intellectual property and then I will focus on copyright and trademark issues, which have been brought about by the internet. I will then conclude by pointing to some other IP issues involving other IP rights and new technologies. So, intellectual property, or IP, is the area of law which provides quasi-property rights or exclusivity over intangible assets to incentivize creation and invention. There are some traditional IP rights, namely copyright, patents and trademarks, and some newer rights, such as trade secrets, design rights, and other sui generis rights over databases and biotech innovations. IP is a fairly internationalized area of law through international treaties such as the World Intellectual Property Organization, or WIPO, conventions, and the World Trade Organization, or WTO, Agreement on Trade-Related Aspects of Intellectual Property Rights, also known as TRIPS. However, these treaties set fairly minimal standards of global IP harmonization, leaving room for interpretation and divergence in domestic IP laws. In this video, I'm going to focus on copyright and trademarks and some of the issues which have arisen through digitization. So, starting first with copyright. Copyright is traditionally a right over creative works in material form. It allows the copyright holder to authorize or prohibit certain actions by other people relating to the copyrighted work. These activities include reproduction, distribution, and communication to the public. It is not necessary to register a copyright in most jurisdictions. The term for copyright protection in Hong Kong is the life of the author plus 50 years. Some other jurisdictions now have longer terms, such as the UK, which is the life of the author plus 70 years. The subject matter of copyright has also expanded in many jurisdictions to cover digital products such as computer software or code. When the internet became publicly available in the 1990s and started to be used more by the end of that decade, various features of this development posed issues for copyright. Computer technology allowed for the digitization of cultural products, such as music, movies, and books. The digital files could be easily copied and sent across the internet. Individuals had the possibility to acquire, copy, and disseminate material, their own or other people's, in much easier and cheaper ways than before. Also, many of the incumbent cultural industries did not embrace these new technologies until too late. In the 1990s, we saw some early litigation on copyright matters, especially in the US. Then the development of new WIPO treaties to address some of the internet developments. But the big shift came in 1998 when the US enacted the Digital Millennium Copyright Act, or DMCA for short. The DMCA introduced an intermediary liability safe harbor and notice and takedown mechanism. It has been replicated to varying degrees in other jurisdictions, such as the European Union's e-commerce directive. Another important aspect of US copyright law is the fair use doctrine. Fair use is a broad exception to copyright infringement, which allows someone to make a fair use of a copyrighted work without seeking permission from the copyright owner. This can be contrasted with the more restrictive fair dealing copyright exception in other common law jurisdictions, such as Hong Kong or the UK. Fair dealing will allow a fair use of a copyrighted work without authorization only in specific circumstances. In Hong Kong, these circumstances are for the purposes of research or private study, criticism or review, or news reporting. If the situation does not fall into one of these categories, in Hong Kong, the fair dealing exception could not be used. The availability of fair use in the US may have been very important for the development of internet services. It is possible that Google, which requires the copying and use of data about other websites for its search engine, could not have emerged in a jurisdiction with only fair dealing exceptions. In a US judgment, it was also held that Google Books, which involves scanning existing books without permission from the authors, met the legal requirements of the fair use doctrine, and so was permitted. The late 1990s and 2000s saw a surge in online copyright infringement by individual users. Various legal measures have been implemented in jurisdictions across the world to address this issue. It is easier and more efficient for copyright holders to target intermediaries through which users may be infringing copyright online, such as platforms, social media sites, and internet service providers. As a result, intermediary liability regimes have been created for these services, accompanied by notice and takedown schemes. More recently, some jurisdictions, including many European ones and now Australia, also have website blocking orders available for the use of copyright holders. In Hong Kong, there have been various consultations on reforming copyright law since 2006, but the Copyright Ordinance has not been amended. Two bills were introduced in 2011 and 2014, which were not passed and implemented. In particular, the 2014 bill aimed to bring Hong Kong legislation up to date for the internet era. It would have expanded the fair dealing categories of exception, introduced a technology-neutral exclusive right for copyright owners to communicate their works through any mode of electronic transmission, and it would also have established a statutory safe harbour for intermediaries regarding copyright infringement occurring on their platforms. However, these proposed reforms have not been implemented, and the Copyright Ordinance remains unmodified and could be characterised as outdated for the digital age. Trademarks. So let's move on to trademarks now. Trademarks are distinctive or unique marks which protect against public confusion as to the origin of a good or service and protect against unfair competition. Trademarks can be registered, usually with a National Intellectual Property Office, which in Hong Kong is the Intellectual Property Department. Or trademarks can be unregistered. Many commonly known brands, such as McDonald's or Microsoft, are also trademark terms. There are various ways in which the internet affects trademarks. I cover the use of trademark terms in internet domain names in the video in this series on ICANN on domain name governance. But trademark terms can also be used to link to sites selling counterfeited products via search engines, and trademarks can be used as auction terms in search advertising services such as Google AdWords. In Hong Kong, according to Refa and Mo, it is an offence under Section 9 of the Trade Descriptions Ordinance to sell goods under a forged or deceptively similar trademark, and this applies to sales over the internet. Also, an internet service provider might be liable under Section 22 of the Trade Descriptions Ordinance, which imposes criminal liability on a person who procures, counsels, aids, abets, or is an accessory to the commission of an act that contravenes the ordinance. It is not clear what level of activity or knowledge on the part of an ISP about their services being used to facilitate the sale of counterfeited goods would be necessary for Section 22 to apply to them. There has been litigation in various jurisdictions around the world about whether competitors can buy auctioned AdWords which correspond to the trademarks of others, or in other words, whether this constitutes trademark infringement. Major cases include the CJEU decision in Google France and Louis Vuitton, where it was found that Google did not infringe trademark law because the sale of AdWords was not use as a trademark. There have also been various cases on this issue in the US, but none have reached the Supreme Court, and different lower courts have come to different conclusions. Trademark owners have had more success in pursuing advertisers which have purchased their trademark terms as keywords. There seems to be no case law in Hong Kong on this issue. I have focused on copyright and trademarks in this video because these have provoked the most discussion, law reform, and litigation around internet matters. But, for instance, patents have been important for the development of smartphones and resulted in the patent wars among major smartphone manufacturers. Trade secrets are also gaining importance in the context of algorithmic decision-making, and calls for transparency regarding how these algorithms work being stymied by trade secret protection. Various new technologies are also creating new dilemmas and opportunities for IP, such as 3D printing, artificial intelligence, and blockchain. While IP infringement may not be as big an issue for digital technology compared to 10 years ago, these technological developments and the outdated laws in places like Hong Kong mean that IP is not going away as an important internet law topic.